Meet Nathan Pearson. He was an attorney in Winnemac, Indiana, up until a few days ago. How he got to not be an attorney is an interesting story. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Lots of young people wind up in a situation where they need legal help. And a lot of times they aren't equipped to deal with the realities of hiring an attorney. And that's especially true when it involves something like a contract or a lease or maybe an eviction problem, that sort of thing. While some lawyers will do some pro bono work, meaning they don't charge for certain services, they help people out. I used to do this all the time with traffic tickets because it didn't make sense to charge somebody for just essentially writing a letter, which is what I did. And as a result of that, I felt pretty good about getting to help people like that. It really made me feel good. But if you are a female and you are in that situation, when you go looking for an attorney, go looking for one, if you're looking for a man who is happily married. You're probably much better off and safer with a female attorney because unfortunately, there seems to have been a rash of cases involving what I would call predatory conduct involving attorneys. That's at the issue in this particular case. And it's really a sad case because there are three women who were treated exceptionally badly by the person who was supposed to put their interests above his own. This case comes to us from the Indiana Supreme Court, and it's in the matter of Nathan Pearson, respondent. And it was decided on February 14th of this year. It's an attorney discipline action. And of course, you already knew that because the thumbnail for this video said, attorneys behaving badly. This one is pretty interesting. And again, a lot of courts have started to do this. They put the answer right up front. We find that respondent Nathan Pearson committed attorney misconduct arising from certain actions he took with three clients. For this misconduct, we conclude respondent should be disbarred. So it talks about how this gentleman, when he was representing client one, who was an 18-year-old woman, so still really a kid, legally of age, of course, could sign a contract, but by the same token, certainly not wise in the ways of the world. And in this particular case, she was arrested and she was arrested on drug charges, and she had a history of substance abuse and having been abused herself as an individual. He went to see her in the jail, and later on, after she was released on her own recognizance, he visited her or she visited him at his home office. This is also a giant red flag waving because if a lawyer wants you to meet him at his home office, most lawyers have, a pretty decent office that they can meet you at. And the only reason not to meet you at the actual office would be to take advantage of things that are not in an office, like, maybe the bedroom, that sort of thing. I would never meet an attorney at his home office. Thereafter, he began scheduling meetings with her. He always wore casual clothing. He had offered her bourbon from a fancy bottle. That's her description. And despite the fact that in Indiana at age 18, she's not supposed to consume alcohol, told her that he was stressed and needed a release from all of that stress. And of course, you can see there in the opinion what he meant by that. So that's what happened. She surrendered to him. And while none of these encounters involved an explicit use of force or lack of consent, she felt compelled to engage in this behavior because of the situation. Respondent and client one also exchanged explicit photos and texts, including messages where the respondent asked her if she was interested in doing other things that were certainly not in keeping with a loving relationship or an attorney client relationship. So after she was convicted, she had to go meet with her probation officer. And she told her probation officer, a guy by the name of Lucas, what happened to her in the attorney's office. So it was resolved by a guilty plea, and she completed probation, and then he asked to have her felony conviction changed to a misdemeanor, which was a fairly nice thing for him to do. And again, he was representing her as an appointed public defender. So in some respects, this is like having the state of Indiana do this to you, because he was an agent of the state of Indiana at that point. So then we have client number two, and this was a woman who was arrested for drug possession. And he initially met with her and her husband at his home office. And about a week later, client two met him a second time after hours at his solo practice office. Because her husband couldn't come along, she brought her two children with her because she didn't want to be alone with this attorney. Take note here. If somebody is giving off vibes that suggest you should not meet with them alone, don't endanger or imperil your children by bringing them along. I understand what her goal was here. Her goal was to assume that this guy would be a genuinely nice enough guy to respect the fact that her children were there in the office with them. That isn't how it turned out. If somebody is giving off vibes like that, listen to your gut. Get out of that situation. There are a lot more fish in the sea, or lawyers in the bar, if you will, and there are other people who can help you and will definitely not take advantage of you. So, being the sociable fellow that he is, he offered her a glass of dark liquor poured from a fancy bottle, and she declined it. Then he briefly discussed her case before turning the conversation around to what he wanted. So he led the client into another room and essentially assaulted her. Uh, and the graphic details that are in the opinion I won't go into, but she testified that she did these acts because, quote, I was a vulnerable drug addict that was in a lot of trouble, and I thought if I did that, I would get out of some of my trouble. Now, keep in mind, she was married at this point, and she did this to get out of trouble. So, again, he is taking advantage of people who are simply not thinking clearly. They're in a desperate situation, and he is essentially pushing himself off on them. It may not necessarily involve force, but what it does do is it takes advantage of a disproportionate level of power that the attorney has over this client's life. And as a result of that, the Indiana State Bar is not going to deal very lightly with this conduct. So she got a plea agreement, and when she talked to the same probation officer, he said, okay, that's two incidents of this guy taking advantage of people. He reported it to the judge. The judge held an emergency hearing. He had to withdraw from that case, and of course, he'd have to disgorge any funds that had been paid. And as a result, she was able to get an agreement that was very similar to the one that he had negotiated for her. Unlike the first two counts, the third instance began when this fellow met this person outside of a legal context. She wasn't soliciting him to become a client. He wasn't soliciting her to become a client. They were just out in the community and they hooked up. So when she wound up being charged with drug offenses, she went to him, paid a $750 retainer, and thought that she'd get good legal services out of that. Like the other folks, he offered her a glass of brown liquor from a fancy bottle, but she drank it. And she has little memory of what happened next. And I think that's as far as I need to go here. So, the Indiana Professional Conduct Rule 1.8 categorically forbids these kinds of things between an attorney and a client unless an intimate relationship already existed prior to the representation. And here's the rule, follow along and fill in the blanks. A lawyer shall not have with a client unless a consensual existed between them when the client lawyer relationship commenced. In other words, it's okay if you were intimate prior to there being a relationship, so long as you don't form the relationship while you are representing a client. Beginning a relationship with a client during representation is inherently exploitative given the power imbalance between an attorney and his or her client. In many ways, this is much like what you see in the situations where teachers are essentially grooming and pushing themselves off on children in the school environment. This is a teacher. She is supposedly a respected person, and she is essentially taking advantage of people in the sixth and seventh and eighth grades, and they do that. I'm not sure what the mental pathology is that makes them do this, but in most of these cases, these are not women who would ever want for a date if they asked, if they made themselves make it known that they were accessible. Most of them are married. And again, this is the kind of conduct that happens inside of a marital relationship. And it's just exploitative and it is exemplary of a serious mental health problem. And while I pity these people, I also feel like you have to be really careful and hold them responsible. The court goes on to say even in situations where an intimate relationship predates the representation, an attorney who proceeds with representation risks placing his or her own interests in conflict with the client's interests. And essentially, Rule 1.8J, which is the rule in Indiana, is a conflict of interest rule. And it's a good rule because it does put you in a situation where you can manipulate and exploit people as an attorney. And in addition to that, they charged him with violation of Rule 8.4 because he accepted the arrangement between himself and the client as payment for legal services. And you absolutely can't do that. At the other end of the spectrum, they're talking about different relationships and different cases that they've handled. So they that are not merely exercises in poor judgment, but that are predatory. And essentially, that's what's going on here. This is predation. He is looking at people who are in desperate situations and he's taking advantage of them. And he's being disbarred, and it can't happen soon enough. Obviously, he's already out of the law practice business because the order was effective on February 14th. Happy Valentine's Day, Nathan. You've earned it. So, here are my final thoughts on this. First of all, if you retain an attorney and that attorney starts coming on to you, whether it's a man who retains a female attorney or a female who retains a male attorney, if there is some push by that person to engage in intimate conduct, then you absolutely need a new attorney and you need to file a bar complaint. A lot of people think that bar complaints don't amount to a hill of beans, but they do. Lawyers have to report every bar complaint that is filed against them to their malpractice insurer, and that's a good thing. If you have been uh, in that situation where you have been exploited, you absolutely should report it to the state bar. Even if it's been 2 or 3 years, you should still report it to the state bar. They might not be able to hold them accountable, but in Missouri, where I was a lawyer, actually am still a lawyer, in Missouri, the statute of limitation runs from the date, not that the client knows that they've been badly treated, but when the state bar finds out that they've been badly treated. So even a claim like this 7, 8 years down the line could still result in disciplinary action against the attorney. If you have any doubts or any questions about whether the interaction was inappropriate, find a good attorney to talk to. Usually, I would suggest if you're a woman, you go talk to another woman and find out who she would recommend that you deal with. Get a second opinion. Was I actually taken advantage of here, or was it something else? And I do want to make the point that there are, I'm sure, certain women who would be delighted to get free legal services in exchange for swapping bodily fluids. But I don't think that's the majority. And I think people who are predators prey on people who are basically good, find themselves in a tight spot, and then they get exploited as a result. It's really not something that the bar should tolerate. It's not something that society should tolerate. And so there you go. So that's what I have for you today. Thank you so much for watching my video. Come on back, join me down here tomorrow. We'll talk about something else. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.